Hello, my name is Melissa Worth and I am a solicitor helping businesses and individuals to resolve their commercial disputes. Each week, as part of my weekly law review, I take a look at a recent case. And this week I have chosen the Court of Appeal case of Allsop and Banner Jones Limited. This is an important decision because it has clarified the position in relation to the doctrine of collateral attack and abusive process. It has also looked at the application of the phosphate sewage test. So to have a look at some key terms before I go on to discuss the facts of the case. To start with, a reminder that the court's decision is final. That is, of course, unless there is very good reason why it shouldn't be. If justice has been served, then there is little to be gained by allowing disgruntled parties to rake over old ground. Relevant to this is the concept of res judicata estoppel. This dictates that when a decision has been made by a competent court, the same issues cannot be relitigated between the parties except on appeal. Its rationale is based on the importance of finality in judicial decision-making. The doctrine of collateral attack and abusive process are also relevant to this case. A collateral attack is essentially an attack on a prior judgment, but not through an appeal. It's made via some other indirect means. Finally, a quick reminder that the court must always be mindful of protecting itself from the misuse of its processes. An abusive process is where legal processes are exploited to achieve an outcome that may not otherwise have been accomplished through legitimate means. So let's now look at the facts. Banner Jones Limited, trading as Banner Jones Solicitors, acted for Mr Allsop in relation to matrimonial proceedings, and Mr Cohen was instructed as the barrister. Mr and Mrs Allsop were divorcing after a long marriage, and after separating could not agree on a division of their assets or an appropriate maintenance for Mrs Allsop. A financial remedy order was handed down, which Mr Allsop was not happy with. He sought permission to appeal, but was refused. Mr Allsop then brought a claim for breach of contract and professional negligence against his legal team. Banner Jones and Mr Cohen, the barrister, applied separately to strike out Mr Allsop's statement of case, on the basis that there was no reasonable grounds for bringing the claim within Rule 3.42a of the Civil Procedure Rules, that it was an abusive process within 3.42b, which constituted a collateral attack on the financial remedies judgment, and finally, that the claim had no real prospect of success pursuant to CPR 24.2. At first instance, the judge applied the test from phosphate sewage, which permits a party to revisit res judicata decisions in certain circumstances. The main ones being where a decision has been fraudulently obtained or where new evidence is introduced which fundamentally changes the complexity of the case. Since these requirements were not fulfilled, the court ruled against Mr Allsop and found that his second claim constituted an abusive collateral attack on the financial order previously made. Mr Allsop appealed, and one of the grounds he put forward was that the first instance judge had erred in his application of the phosphate sewage test. As I've already mentioned, res judicata estoppel will prohibit relitigation where the issues and parties in dispute are the same as those in the previous claim. However, in this case the parties weren't the same. The original case concerned matrimonial proceedings relating to Mr Allsop and his former wife, and the second claim related to allegations of breach of contract and negligence against the legal team. So, as the issues and the parties in question were different, the court agreed with Mr Allsop and found that the phosphate sewage test was simply not relevant as to whether the subsequent proceedings were abusive. That said, the court was mindful of the need to control abusive process and considered that, where the parties and issues are different, an attempt to demonstrate an abusive process is better framed by reference to the test set out in the 2003 case of Secretary of State for Trade and Industry and Bairstow. The test in that case provides that it must be considered whether it would be manifestly unfair to an original party to have the same issues revisited and whether to reallow litigation would bring the administration of justice into disrepute. The court concluded that the right to strike out proceedings as an abusive process is an exceptional one, and that this right should not be rigidly applied, and so the circumstances of each new case needs to be carefully considered on their own facts. This case demonstrates just how important it is to carefully consider the facts of the case, the parties of the case, etc., before embarking on issuing court proceedings. If you have any queries or comments about this case, I would love to hear from you. Many thanks.